Good morning, thank you for joining us today for our webinar. Today we're looking at the Party Wall Act. My name is Katie and I'll be guiding you through this morning's session. If you've got any questions at all that you wish to ask, I'll be handling those and handing them to the presenter. You can type your questions. There's an admin panel on the right hand side of your screen where you can send questions to us. Questions that are quite specific we will probably come back to you directly at the end, but if you've got general sort of questions, we'll do our best to incorporate them into the presentation this morning. You can also contact us on Twitter using the hashtag CABECPD. So this morning, what will you learn? You will be looking at the main provisions of the Act, the processes to follow, and you'll be getting an understanding of the role of the Party Wall Surveyor. Your presenter today is Kevin Blunden, who's our Deputy Chief Executive, who looks after all of the technical side. And without further ado, I shall hand you over.
Right, good morning and welcome to this webinar on the Party Wall Act. As Katie said, we will take questions during the webinar. If they are a little bit specific in nature, we probably will come back to them after the webinar, and we will, as we have been with all of these recently, be posting a list of the frequently asked questions and their answers on our website once we've completed. I want to start the webinar this morning by asking you a quick question, just so that I can understand where the audience is in terms of experience and the role you undertake. So I'm going to open up a quick question to ask you how you've been involved with the Party Wall Act to date. Basically, to get a concept of which side of this you're coming at. So now there should be a poll open on your screen asking you whether you've worked as a Party Wall Surveyor, whether you've worked as a designer, a client, you've been involved in a project but not directly under the Party Wall Act, so perhaps just given some peripheral advice, or you've actually been involved as a neighbour who's received a notification. That will just enable us to get a feel for where we're pitching the audience. I'm sort of hopeful in my own right that we haven't got hundreds and hundreds of Party Wall Surveyors on the line who, you know, probably be a bit like teaching the grandmother to suck eggs this morning. But yes, we're getting to the stage now where the majority of you have voted. Just a couple more seconds, I'll leave the poll open. And right, I think we're pretty much there in terms of everybody voting. Okay, closing in 3, 2, 1. Okay, we'll close the poll there, and I'll share those results with you so you can see what the audience is. You get an idea of who's participating this morning. So we've got roughly 20% of the audience work as Party Wall Surveyors and roughly the same percentage working on the design side. And we've got a few operating from the client's basis, but as I suspected, quite a large number today who are involved with the Party Wall Act, but not directly in one of those roles. And obviously, from that point of view, we'll try and pitch it so that we make sure we cover that level of information. Right, if I can get the technology to get us back to the presentation, we'll roll on with what's included within the Party Wall. The reason that the association gets involved with the Party Wall Act is that the government issue a guide for householders, and we are listed at the back of that guide as one of the bodies they can come to for advice. And quite often we get members of the public approaching us at the association, and we then actually refer them to members who practice at Party Wall Surveyors if it's something in the locality. The guidance that the DCLG have pushed out for householders has recently been updated, and there is a new January 2015 edition of that available on their website. It covers off some of the main points, but obviously some of the actual detail has to come out of the Party Wall Act itself. So the first issue is to look at what is actually a party wall. And obviously our general understanding in general terms of party walls are the walls separating properties. As far as we're concerned under the Party Wall Act, a party wall is the wall that sits astride the boundary. It's part of one building or separating two buildings, and it can consist of this strange concept of a party fence wall, which is something that isn't actually physically part of the building but stands astride the boundary line. And this is obviously where we tend to get a lot of queries from the public. So it's a fairly broad definition, but it sort of follows the general common sense understanding of what the party wall would be. Once we've established there is a party wall involved, then depending on what work we're looking to do, there will be certain processes we have to go to. As I said just now, there is a new updated version of the explanatory booklet that can be found on the planning portal with a lot of other guidance for other bits of legislation. But it's minor tweaks to make it easier to understand, so I'm not going to dwell on the actual booklet itself. The basic principle of the Party Wall Act is to set down a framework to resolve disputes, and it's intended to be a tool to assist in development and allow building owners to carry out works. Unfortunately, it tends to be seen, particularly by the general public, as a means of frustrating work, or almost a second bite of the cherry if they've been unsuccessful in lodging a comment under the planning process. And that isn't the purpose of the framework, and it's not intended to be something that actually causes the work to be abandoned altogether. It is there really to protect the rights of the individuals involved in the process. And in advising clients to follow the procedures in the Party Wall Act, particularly if they are the individual carrying out the work, they actually end up with a greater degree of protection for subsequent claims than they would have if they hadn't gone through the process in the first place. Some work that's fairly minor in nature, you don't necessarily have to worry about when you're doing the party wall. So simple things like fixing things to the wall, nail screws, picture shelves, that sort of thing. That's minor work, and it's quite clear in the guidance in the Party Wall Act that it's not notifiable. When it comes to things like injecting a damp-proof course, or maybe cutting in a cavity tray or cutting in a damp-proof course, that then is bordering on the issue that we may have to look at notification depending on what we're going to do and the impact on the neighbour. So in terms of the work that's subject to the Act, basically if you're doing work on the boundary line or close to the boundary line, then it may well be that you've got to consider the requirements of the Act. So where you've got different owners either side of a boundary, the land hasn't got a building on the line of junction and the boundary, then that will be work that is subject to control under the Act. And we have to then try and make sure that we start this process and enable the development to take place in an amicable way. And one of the major problems that we find is that the parties involved quite often resort to a formal legal written process because neighbours just don't tend to talk to each other very much anymore. So the sort of work we're looking at that is going to require a notification will be things like cutting into the wall, demolition, rebuilding, underpinning, removing chimneys, taking off overhangs. That basically will all require a notification under the Act, and from that basis that's where we start having to look at what are we going to do to protect the neighbour if any damage occurs, what's going to be done to put it right, and how are we making sure that the work is undertaken in a safe manner to ensure that during construction and post-construction there's not going to be an adverse effect on the neighbouring property. Right. I'm just going to break there very quickly because I can see we've got a few questions coming in. Now, I think as Katie had perhaps anticipated with the questions, some of them are looking quite specific and quite detailed, and I think certainly some of them we will have to come back to afterwards. There is an element, I think, of a couple of common issues. There's a question particularly about things such as cutting in cavity trays, and that clearly would be covered under the provisions. Can we use the Party Wall Act to force somebody to pay towards removing a joint chimney? When it comes later on, we will see that there are issues around who pays for work, and a lot of it depends. Ordinarily the work, the cost will, under the award, rest with the person carrying out the work, but if it can be shown that obviously a lack of maintenance has contributed to the costs, then that may well be apportioned under the award. And I think there's one question sitting there about the typical cost of a party wall surveyor, and I think we'll touch on that when we get to the process later on. looking at just how many surveyors might be involved in the process. So if we just move on a little bit to some of the areas that perhaps we're a little more familiar with, one of the fundamental issues under the Act is to deal with the concept of undermining the neighbouring property and the neighbouring foundations. And we end up with a couple of instances that, depending upon the depth of the excavation and the distance to the neighbouring property, there may be a requirement for a notification. So the common one is the 3-metre notice, where the excavation is going to be within 3 metres of the adjoining owner's building and lower than the bottom of their foundation. And I think it would be fair to say that in an awful lot of cases, people proposing work, and a lot of the inquiries I get from the general public at this basis, are along the lines of, well, yes, I'm within the 3 metres, but I'm not intending to dig lower than my neighbour's foundations. And as I'm sure many of you are aware, you can never be sure before you actually start the building work quite how deep the foundations will go. And it tends to be the case that if you're digging a foundation and having to meet the requirements of the building regulations under current standards, that you may well end up deeper than the neighbour's foundations if they were built more than about 30, 40 years ago. So I would honestly say, although the Party Wall Act says that it's a notification that's required if the foundation is going to go lower, unless trial holes have already been excavated and you can actually ascertain the depth of the neighbour's foundation, it really is a case that, to be on the safe side, that notice ought to be issued in any case. But that is a view that a lot of owners will try to shy away from, because obviously this would then require them to start considering appointing a surveyor and actually engaging their neighbour in the process. Alongside that, then, we have the similar requirement if we are a bit further away from our neighbour's property, and that's basically still looking at the effect on neighbours' foundations in terms of the bulb of pressure that we find under a foundation, and making sure that nothing actually would influence that. So again, if we're looking at a particularly deep foundation that's 6 metres away and we're going to be below that 45-degree line, so in other words, if it's 6 metres away and it's more than 6 metres below the foundation, then again a notification is going to be needed. So those are the fundamentals, if you like, when we're looking at development in relation to neighbouring properties, rather than actually something involving the line of the wall itself. And that can be summarised in this sort of sketch, where we end up where any excavation within a zone, from the new build point of view, is going to require a notification to be served. Right, I'm going to now ask Katie if she's had a chance to look at any of the questions and whether there are any common themes that we need to pick up on.
Hello there. There's a few questions coming in about verbal agreements and whether, if there's a verbal agreement between perhaps neighbours and some sort of signed documentation, is there any need then to employ a surveyor?
In general terms, although the Act applies, if neighbours get on quite well and they can come to a verbal agreement on what's got to be done, that's all well and good. But I would always say that any provisions and anything that's agreed does need to be wrapped up in writing. It doesn't necessarily mean that you have to get a surveyor involved if the parties can agree. But obviously, to a certain extent, what is decided will affect the properties going forward as well. And should an owner change, it's important that there's some record of what was agreed and what consents were given. So although they may well work on the basis of a verbal agreement, anything as a result should be confirmed in writing, and that should be kept safe and secure with the property details, just so that it covers things moving forward. But it is preferable from the owner's point of view quite often if you can come to an agreement. And even if you have to get a surveyor involved, it is better if you can do it on an amicable basis and agree to appointing a joint surveyor than maybe going through the process where we can potentially end up with a confrontation type arrangement occurring. Is there anything else there, Katie?
Just also whether the Act is applicable to outbuildings, so garages and sheds, etc. Yeah.
In terms of the notices and terms of buildings, obviously what we're looking at is a slight difference between work on the party wall line. So if the outbuilding, the wall of the outbuilding forms the boundary and the party wall, that then is covered as part of the party wall. But generally, if we're talking about lightweight structures such as sheds, this business of undermining the foundations, although it's a consideration, if it's a lightweight structure at that point, it's not a major issue. But that you will have considerations, particularly if you end up with things like double garages and that sort of thing. There will still need to be some consideration because potentially there is still damage that could be caused.
Lovely, thank you, Ken.
Okay, right, we'll move on to the second quick question that I've got for you this morning, in terms of if you've been involved with a project or of the projects you deal with, how many of them are affected by the party wall? So even if you're not dealing with the Party Wall Act yourselves, under the sort of criteria of actually working on the party wall in terms of cutting in or removing chimneys or the excavation in proximity to another building, what sort of percentage of the projects that you actually deal with would be covered by the Party Wall Act? And what I've done is basically broken the answers down into percentages, which hopefully you can see in front of you now. So my own feeling is that an awful lot of projects, particularly in the domestic sector, will be either involved work on the party wall or in close proximity. So I'm just trying to get a feel for that. And this is more really just to get an idea of the effect of the Act and how much it's actually out there being used, and also a level of awareness, I suppose. Right, so I'll give it another 10 seconds or so to finish the voting off. Our little scale is clicking up. Okay, and I think we're more or less there with that. Okay, so I'll close that now. Right, and pop that up on the screen so that you can see it. And that seems to be, I suppose as a graph goes, it's a fairly consistent answer across the board. So that actually, I suppose, doesn't really lead us to any great conclusion. Obviously people will be dealing with a variety of project types, but there are an awful lot there, you know, around the 20% mark, that share all the percentages through. So I suppose we can just, the only conclusion from that is that there's a wide variety of work, bearing in mind that a good percentage of you are working as party wall surveyors. That obviously I would expect that to be at the top end of the scale, because pretty much every project you'll be working on as a party wall surveyor will obviously be impacted by the Act. So yeah, I think that would need some very clever number crunching to come to any firm conclusions on that poll, to be perfectly honest. And it's perhaps not quite what you'd expect. You'd sort of expect the clear lead of saying 50% of the projects were involved or something of that sort. So yeah, it's not perhaps as cut and dried as I would have expected from the poll. So moving on, in terms of whether we have to serve a notice, we can follow a number of approaches, but in general terms, if the work is building a new wall or an external wall at the boundary, if we're doing structural alterations to the party wall, or we're excavating near the building, then if any of that is happening, then we need to serve a notice before we start the work. And generally that period is 2 months before, but it reduces down to 1 month if it's a new party wall or structure on the boundary, or for any excavation. If you're not doing any of those works, it's quite clear you can carry on. The Party Wall Act doesn't apply. Perhaps the issue then is what happens if I want to carry on quicker than the 2 months. And reality is that if you can get the neighbour to agree to the process and run it through, then notification is still required, but as soon as you've got the agreement to carry on, you can move things forward. But it does potentially mean an additional delay, and this is something that quite often doesn't get conveyed to the client in terms of what might stop them crashing straight on once they've got their planning permission, once they've got their building regulation approval, that they may actually incur an additional delay. And a lot of the inquiries we get here are from neighbours where work is starting imminently and they want to know what can be done because they haven't served a notice. And at that point, the neighbour's options really are to look at serving an injunction until this thing gets resolved. And that sort of leads us to where we start to rise into difficulties, because if the other party doesn't agree or simply doesn't respond, then we end up with a situation where the parties are in dispute. And again, I'm going to ask you for your view on how often you think these projects actually end up as a dispute. So again, it's a sort of a percentage basis of the projects you've been involved with. How many are you aware that result in a dispute between the parties and maybe aren't agreed at the first instance, or we don't get a simple notification and yes, carry on process? Okay, so the results are rolling in on that, and this time there is an out-and-out leading answer. I'll just give it another 10 seconds or so to close off anybody else who's going to vote. Okay, we're more or less there. So I'll close that one now. And in terms of the results of that one, I think quite surprising from a personal perspective, purely by the number of phone calls we get from people who are concerned. The majority tend to feel that less than 20% of the projects actually end up in a dispute, which is quite reassuring, and possibly means that more neighbours actually get on than you think for, or that actually the framework of the Act is working. So moving on from there, if we look at what does happen once we start dealing with notices, a dispute can occur either because there is a genuine issue, or simply because the adjoining owner hasn't responded. So if a notice is served and the adjoining owner or owners haven't responded within 14 days, then it's automatically considered that a dispute's arisen. Similarly, if they do respond within that 14-day period but they're not agreeing to the proposed work, then again we're into a dispute. You can also get a situation where, having received the notification, the adjoining owner will serve a counter notice, and again, if that counter notice isn't responded to, then we're into a dispute situation. Once we've got to the situation where a dispute's arisen, there really is no option other than to start looking to appoint surveyors. Now at this point, the client can opt to appoint an agreed surveyor, which, as the guidance would suggest, is a surveyor who is agreed by both of the parties involved, or all of the parties involved, and that surveyor will then act in an independent manner to come to a conclusion that is fair to all. So they will draw up an award in relation to the Party Wall Act that comes to a conclusion that, from an independent perspective, is fair to all parties. Alternatively, if the parties won't agree to a single agreed surveyor, then we may end up with each surveyor appointing their own surveyors, and they will then work to draw up the award. Now, I'm going to ask a question about your perception about how do party wall surveyors become involved in the projects. This is something that is a little bit contentious, and we do get a lot of inquiries at the association about in terms of how party wall surveyors become involved. So the options I'm giving you in terms of the answers here are, firstly, that the client seeks out the services, so they come to a professional body, or they go to some other reference to find a party wall surveyor. Or designers will recommend a surveyor, possibly others involved in the process, building control, maybe the builder, recommend somebody, or that the surveyors actually actively go out and seek the work based on looking at current planning or applications and the planning registers and finding work in that way. And I'm interested here to see where the split is, because there are concerns from some sectors about whether people are allowed to recommend individuals, and there are also some concerns about things such as the review of planning registers to see where work is available. Right, the votes have slowed down on that one, so I'm about to close the poll. Right. And we'll close that one off and let you have a quick look at those results. And an awful of it would seem to be honest, that the professionals involved in the process are advising on surveyors, or clients are actually aware of what they need to do and seeking them out. So hopefully at some level the client's awareness of the Act is being raised, whether that's planning departments mentioning it, building control or whatever, that somebody is making the client aware that they need to look at the considerations of the Act. So that's quite pleasing from that point of view. Right. In terms of once we get the surveyor or the two surveyors involved, if there's an agreed surveyor or surveyors acting for each owner, they will draw up an award, which is basically a process to look at what's going on and, if necessary, what compensation is there, that sort of thing. Now, if the two surveyors can agree, that's fine, the award can be agreed, we can move forward and start the work. If the two surveyors can't agree on the content of an award, then a third surveyor has to be obtained to feed into this process and arbitrate between the two. And this perhaps feeds back to that very early question about how much is this process going to cost, and the client's reluctance, if you like, to get involved with the Party Wall Act. Obviously, there will be quite a wide variety of fees involved depending on the complexity of the project. Generally, though, obviously from the client looking to carry out the works perspective, there are going to be benefits in appointing an agreed surveyor. The principle of the law and the Act is that the person who wants to carry out the development is going to bear the cost here. So obviously if there's an agreed surveyor, the person carrying out the work will carry their costs. If the parties appoint individual surveyors, then the principle of the Act is that the person carrying out the work still carries the cost of those two surveyors. Now, there is a reasonable caveat in all of this, that it's reasonable cost. So if the surveyor acting on behalf of the neighbour has extremely high costs for no discernible reason, then that can obviously be challenged. But in essence, the cost of the surveyors in this process fall to the person wishing to carry out the work. And depending, as I say, on the complexity of the job, you could be talking anything from £250 up to maybe a couple of thousand. It depends on the scope of the work. The average, I would say, probably pitches in at somewhere around about the £300–400 mark. But obviously, the more surveyors involved, the more that's going to escalate. And at that point, perhaps having sort of dealt with one of the earlier questions through that, Katie, are there any other questions coming in at the moment?
Hi, Kevin. There's still quite a lot of comments regarding neighbours and agreements and confirming things in writing. So I think what I'd like to say to everybody is we will cover that off in some frequently asked questions that we'll post online after the event, and we'll kind of consolidate all of these questions. There's a few questions, if you can see the one with regard to building notice process, and the fact that it's more of a lack of knowledge of the requirements of the Act, which is perhaps why notifications aren't served.
Yes, I think as an industry we are trying to make sure with a great number of things now that the public particularly, not so much in the commercial sector, there tends to be a greater awareness of what's going on, or a greater level of information from their professional advisors. But on the smaller domestic jobs, there is an issue about awareness of legislation and how it applies to the householder. And there has been a move to try and persuade planning authorities particularly to include information when they issue their approvals to remind householders of their obligations under the Act. Building control will tend to try and do the same thing. The problem with the building control process is quite often, either with a building notice or if somebody's put in a full application, work will start before we get to a decision on that application, and therefore that bit of paperwork advising people about the Party Wall Act doesn't necessarily get to the end user. So certainly, we would have a hope that the people advising people on the work, the people drawing the plans, the architects, the smaller designers, would be advising the client that in addition to dealing with building regulations and potentially planning, they also have other obligations under the Party Wall Act. And this is a message that will be reinforced later this year as well, because individual householders will start to become responsible for some of the issues under the CDM regulations for health and safety. So there needs to be a general awareness raising of householders in terms of all legislation. But as far as possible, the intention is at the moment through the local authority framework, through planning, through building control, to advise and to raise awareness through all professional advisors so that they are telling their clients that they need to do this. But unfortunately, a lot of the smaller domestic work, the client may not go for professional advice. They may just get a builder in to give a quote and crack ahead with the work. And it's that level that needs to be addressed in terms of getting the message across.
So,
okay, is there anything else,
yeah, just
Katie?
on what you've just said, actually, from the builder's point of view, I've got a couple of questions from that perspective. At what point would a builder get a surveyor involved? Would that be if the party couldn't agree, then the builder takes on that responsibility?
No, theoretically, under the Act, all of the responsibility still stays with the owner wishing to carry out the work. So whilst the builder may act as an advisor to the owner, it's not part of the builder's role to actually engage the surveyors in this process. They would still be engaged by the owner of the property. Now, it may well be that some builders will wrap it up in a package, and they may well have surveyors that they can recommend, but ultimately it's the owner's responsibility to sort this out.
Lovely, thank you, Kevin.
Okay, right, we'll move on to the next quick question then, which is how often in the cases that you've been involved with do we actually get to the stage where we've had 2 surveyors appointed, they haven't been able to come to an agreement on the award, and therefore we have to go to the 3rd surveyor. So I'm going to launch this question. I've only given it 3 options: rarely, frequently, or in the majority of cases. And I'll be perfectly honest, at this stage with the votes coming in, I'm expecting most of this to say rarely. Okay, so we are rattling on with the audience in terms of voting. Okay, nearly there. I'll give it another 5 or 6 seconds. We don't want to take too long on this. Fine. Okay, I think we're there. And yes, as I'd expected, and probably as you would have as well, it's very rare that we get to the 3rd surveyor becoming involved, which I suppose is an indication that once we get professionals involved in the process, we can usually come to some sort of negotiated resolution, which is what we would expect. The difficulty, I think, with all of these things is that when you have an agreed surveyor, or you have individual surveyors working for each party who then come to a joint decision on the award, quite often the party engaging the surveyor is not happy with the content of the award. But as the process goes, because it's been done either as an agreed surveyor in an independent matter, or it's been an agreed award between 2 surveyors, they are pretty much going to be stuck with the content of that award. There are some issues when you've got 2 surveyors involved in terms of what you can do if we're not happy with that. But generally, the award will stick. Now, what you would expect to find in a party wall award would be details of which parts of the Act we're dealing with, so whether we're dealing with a 3-metre notice, a 6-metre notice, whether working on a line of junction or what have you, details of the parties involved, a full description of the works, a summary of the duty and rights under the Act in terms of things like access and the like, and then the conclusions and the signatures. And that may well include things like compensating matters and an issue in relation to payment. So generally the award will detail what work needs to be carried out, how it's going to be carried out, when it can be done, if there are any restrictions on things like noise levels or times when it can be done, that can be detailed within the award, although obviously there is general environmental legislation that would cover additional requirements to that as well. The award might also detail any extra work that's going to be required to protect the neighbouring property and to prevent any damage, or detail the way in which the work may be carried out. So that it could well be that as part of the award the conclusion is that we move to something like a raft foundation, or something that's not necessarily going to undermine next door, or something of that sort. In addition, then, there'll be a record of the condition of the adjacent property before the work begins. And this is one of the fundamental benefits to the client, and one of the persuading factors in terms of why they should opt to go down the Party Wall Act route with notifications rather than to avoid the legislation. Because if you go down this route and serve a notice, then you can do a benchmark survey of the neighbouring property to ascertain its condition. And the advantage of this is that if the property is has suffered movement in the past, has suffered any damage, that baseline survey before the work starts will record all of that. And then it's quite clear at the end of the project whether that work has been caused by the work that's been carried out, or whether it was pre-existing. If a client chooses not to serve notice under the Party Wall Act, there is an element at the end of the job that if the neighbour then claims damage, it's far more difficult to prove whether it was pre-existing or not. So actually the liability of the client could be much greater if they haven't served the notices and gone through the process. The other thing that will be covered off in the award will be issues like access in terms of inspecting the work and making sure that the requirements of the award are carried forward and dealt with. So that's the general sort of process. The idea is that in terms of where we are and where the costs sit for anything that's included within the award, normally the building owner will pay for the work that's required by the award. The only issue that may vary that is where the work is required because the neighbouring property has not had sufficient maintenance, or is in a defective state, or has a lack of repair. Then there's an element of the adjoining owner will have to bear some of the cost for that. And of course, as part of the award, the adjoining owner might ask for some additional work to be done as a compensating measure or at the same time, and therefore the adjoining owner may make a contribution to that work. Generally, the award should only relate to the works covered by the notices. So if there's anything else that's a matter of dispute, or any other work going on that's not relevant to the notice, that wouldn't normally be covered off within the award. And the award really shouldn't deal with anything else in terms of easements or covenants or restrictions or personal arrangements between the parties. That really is, again, beyond the scope of what you would expect to see within an award. And generally, the award is final and binding on all properties, unless you appeal to a county court and get it rescinded or modified. Once the award's been set, then each owner has 14 days to appeal that process to the county courts. One of the issues that quite often crops up in terms of party wall issues is access to neighbouring premises. Does the builder have a right to come across my property? Is there a right of access? There are access issues built into the legislation, primarily around the determining of the condition of the property and the process to set up the award. There is a requirement for notification to be given. However, the neighbour must allow that access, and if access is refused, ultimately that can then end up in the magistrate's court to enforce that the access is granted. Some of the common issues that arise around the Party Wall Act is that the client disagrees with the appointed surveyor, even if it's their own surveyor, they're not necessarily happy with what the conclusion he's come to. Having appointed a surveyor, the surveyor has to act ethically and to look at the matter from an independent standpoint, so the client can't necessarily rescind that appointment. If they have a total issue with the surveyor they've appointed, and both parties are using individual surveyors, the client could potentially approach a third surveyor But if you're using an agreed surveyor, you haven't really got that option. The other issue is that work has started without a notice, work started with a notice, but you can't reach a solution. There's a dispute and work wants to carry on up straight away. Ultimately, it may well be an injunction if work starts before things have been resolved. And the Act doesn't deal with boundary disputes about where the boundary line is. That has to be sorted out in an independent manner, although people tend to think as part of this process that it will resolve boundary issues as well. So those are some of the common issues that we come across. Are there any other questions that have come in, Katie?
Hi, just got a couple of people asking regarding templates for the awards. Are there any available that people can use?
Whilst the Act itself and the guidance booklet includes some template letters for notification, they don't go as far as templates for the award because there is quite a variety of what can be used. Some of the professional organisations that support party wall surveyors, such as the Faculty of Party Wall Surveyors or the Pyramus and Thisbe Club, they basically will have some guidance document for surveyors as a sort of a format to use. But it's not something that's out there in the general arena because I think there's an element of wanting to make sure that the people acting as party wall surveyors have sufficient knowledge to be able to do that. Okay, are there any other?
It's mainly, again, common things about awareness and one that you've covered on access and refusal of access as well. So, but obviously you've covered those off.
Yes, I think looking through, there are some of the questions are quite specific in particular issues, and we will come back to those afterwards. There are some general things such as, if you're acting as a designer on a project, what is your responsibility in terms of advising the client? And I think it's like anything else. If the client's engaged you to do a design, to get the necessary statutory approvals, get them to a stage where they can start work, I think it would be a little bit strange if during that process you hadn't highlighted to the client that the Party Wall Act would apply and there would be this other procedure they would also have to go through, even though it obviously might not be something as a designer that you're dealing with on their behalf. So yes, generally any professional, I would say, needs to be highlighting this as soon as it becomes obvious that there is going to be a party wall issue. Whether that extends to the other professionals, the planners, the building control, again, I think there is an issue of raising awareness, but it is clearly, because the Party Wall Act is civil legislation, not something those parties can actually deal with, but I think it should be flagged up to people when they're looking to do that. And clearly in terms of things like government, all of the websites that they have giving information to people considering doing work do make reference to the Party Wall Act. Okay, I think that's probably covered the bulk of the questions that aren't too specific. So what we will deal with is the rest of the questions in our frequently asked questions spot after, or we'll come back directly by email. So in terms of where we are with this now, I think we've covered most of those issues. And at this stage, I'm going to hand you back to Katie to wrap up. Thank you very much.
Thank you, Kevin, and thank you for joining us, everybody, this morning. We will be having a further webinar on the 11th of March. The next one that we're holding is a membership clinic. So if you've got any questions regarding membership of CABE, the application process, or upgrading your membership, then you can talk directly to our membership team. Just also with regard to the Party Wall Act today, don't forget, if you do work using the Party Wall Act, you can also add this to your preferences in the Find a Building Engineer directory so people can search for those services. So it's a good opportunity for you to log into our website and update your profile. Again, thank you for joining us, and we'll see you online next time. Thank you.